morning, everybody. We'll just let everyone still come into the room. We have a big audience today, so we just need to give a couple of minutes for everyone to come in. And then meanwhile, Lexa, you're not letting River in to join us? Your giant dog, no?
No, she has been kept out. No interruption. Yeah. Yep.
Nice. She's very helpful. She sits there and stares at your head. It's really cute.
Yep, yep. And none of your cats either.
Yeah, we'll see what happens there. They've learned to jump up and walk in front of the computer, so we'll see. I see people are coming in. Why don't we get started with the intro stuff, and then that'll give some more time for everyone to settle in. So welcome everybody to our episode 54, Tricky Terminations. My name is Lisa Stam. I'm a lawyer at SpringLaw, and I'm joined today by Lexa Cutler, another employment law lawyer on our team. Thanks for joining us for this month's webinar. Tricky Terminations has attracted a lot of attention. We've got great numbers. So clearly this is a very hot topic as we all continue to navigate the post-pandemic workforce issues. For those new to our webinars, welcome. We're a virtual Canadian law firm specializing in employment and contracts law. Feel free to ask any questions through the chat along the way. And if we can't get to your comments, just follow up with us afterwards. You can download the slides under the Handouts tab, and for more resources, please visit our website at springlaw.ca, where you will find our award-winning weekly blog, a free policy compliance checklist, a link to subscribe to our monthly newsletter, and info on our subscription program for employers and some DIY legal products. Okay, let's get started. We have a big day. Of course, first and foremost, we would like to begin by acknowledging that the land on which we operate is the traditional territory of the Anishinaabe, the Haudenosaunee, the Huron-Wendat, and the Mississaugas of the Credit First Nation, who have stewarded these lands for generations. We recognize that Indigenous people lived and thrived here long before the arrival of the settlers, and we acknowledge the lasting impacts of colonialism. As part of our commitment to truth and reconciliation, we strive to learn, unlearn, and understand the history and effects of these wrongs, and we are grateful to live and work on this land. We have legal disclaimers here like we do for every webinar. This is all legal information, perhaps especially today because we're dealing with these high-risk, complex terminations. It's all very fact-specific, so this is all legal information. Here's to reinforce that point. And let's talk about what our roadmap is for today. So Lexa will start by setting the stage and give a brief overview of the core termination entitlement benchmarks. And then we're going to walk through 7 tricky termination scenarios to flag the legal risks and the modified approaches required with these tricky terminations. So over to you, Lexa.
Thanks so much, Lisa. So we're going to start off with just a basic overview of terminations in general. So you've decided for whatever reason that you need to terminate an employee without cause. Other than briefly in the next section, everything else today that we're talking about is to deal with terminations without. So the first place you're going to want to look if you're planning on terminating an employee is to look at their employment contract and check their termination clause, notice periods, and severance obligations. Then in general, there are 3 buckets of termination entitlements. The first is from the ESA or whichever employment standards legislation applies. So their notice period, severance, continuation of any benefits, and any unpaid wages or paying out unpaid vacation. And then the next bucket of termination entitlements is anything from their contract. So they may have negotiated or the company may have offered a entitlement on termination that's above their Employment Standards Act minimums. So that's important to note when you're going to terminate someone. And then finally, the third bucket is the dreaded common law. Here's where things get tricky. Even in our, basic terminations 101, this part does get tricky. So in the absence of a clear enforceable termination clause in the contract, common law will apply, and employees may be entitled to much more than their ESA minimums. Factors that increase common law can be things like an employee's age, their length of service, their position, and the availability of similar employment. So it's very fact-specific, very different for each employee. The longer service, more senior and older the employee, the greater their common law entitlement will be. Typically, the rule of thumb we say is that for every year of service, it will be about 3 to 5 weeks of common law notice. So then at the bottom, we have our upstream tip. So for each of our topics today, we're going to be talking about handling the termination itself and at the end of the employment relationship, but we'll also be providing what we've called upstream tips, which are steps you can take earlier in the employment relationship prior to termination that can help make the termination process run more smoothly and also reduce liability for the company. So this upstream tip is something that all of us have said so many times, and you may have heard from us as well, which is regularly review and update your contracts to align with current legal standards. Proactively managing your contracts can really reduce your liability down the road. So if your contract hasn't been updated in the last 5 years or even in the last year, there's a risk that it may not be enforceable. So you want to keep updating those and keep on top of that.
Lexa, we have a question here. How do you terminate an employee who never signed their employment agreement but has worked for almost a year?
So if they haven't signed their employment agreement, then they are going to be entitled to that common law notice unless they have a valid enforceable termination contract and clause that limits their entitlements to their ESA minimums. They're going to be entitled to the common law notice that we were just talking about. So if they're about 1 year, it may be about 1 month, but it's going to depend on a lot of factors. So their actual entitlement will be.
And this is the big difference between Canada and the States, is that if there isn't a contract in place that's properly signed before they start, the courts will imply terms. They will imply that there is an underlying contract that governs everything, and that is the common law.
Yeah.
Okay, next.
So next we're talking about just cause termination. So this is the only time today we'll be talking about just cause. As I mentioned, everything else will be without cause. But the first question is, if you're thinking about terminating an employee with cause, is should you terminate for cause? Let's say you have an employee who's been either behaving badly or performing poorly and you'd like to terminate with cause. With cause terminations are almost always more contentious, and sometimes it's going to be the best business decision to opt to still terminate without cause, even where misconduct is present. If the termination devolves into a legal battle, say a wrongful dismissal claim, it may have been less costly for the company to have just paid out whatever their termination entitlements were upfront at termination than to engage in a legal battle. So that cost benefit analysis is something you're going to want to engage in before you make the decision to terminate one way or the other. It's going to be unique to each situation. There's a high threshold for just cause. When you terminate an employee with cause, you're not required to pay them any notice or any severance, but the standard is very high, both under the common law and under the Employment Standards Act. Judges and lawyers have been known to describe just cause terminations as the capital punishment of employment law, which may sound dramatic, but it shows how difficult it is to establish and how high that threshold really needs to be. And then finally, the last point we'll make on just cause terminations, this is a really complex topic and we could do a whole hour-long webinar just on just cause termination. So we're not getting too into the weeds here, but we want to flag that you'll need progressive discipline where applicable. So employees should be given verbal warnings, written warnings, suspensions, or other form of discipline prior to terminating with cause. There are very rare situations where one single incident can justify terminations for cause, but it usually requires demonstrating a pattern of progressive discipline and that the employee was informed that their behavior was not acceptable and they were provided with an opportunity to improve. So our upstream tip here is, obviously for all of these throughout, the theme is going to be documenting things, writing things down, but I've tried here to give a different type of tip, which is ensure consistency in applying disciplinary measures across the organization. So if you don't want people to be late, you need to consistently write people up, consistently discipline people when they're late. You can't pick and choose who you apply that to, because if similar misconduct has been handled less severely with other employees, terminating one employee or treating them differently could lead to unfair treatment and or claims of unfair treatment or discrimination. And it also takes away from your position that this is unacceptable behavior. So consistency reinforces the employer's position that the termination is justified for cause. So next, we are talking about leaves of absence, substantive legal issues. So when terminating without cause, employees can generally be terminated at any time and for any reason, as long as you provide notice or of whatever they're entitled to from those three buckets. But there are a few key exceptions to that. Terminations cannot be discriminatory. You can't terminate someone based on their characteristics that are protected under human rights legislation, such as disability, gender, family status. And you can't terminate someone based on their use of job protected leaves. So taking a parental leave, a compassionate care leave, things like that. You can't terminate someone because they've requested to take those types of leaves. You can't base a termination even in part on those protected characteristics. So even if there's a general business reason, if the decision to terminate was tainted by one of those discriminatory factors, the whole thing is discriminatory. So you need to show that none of the decision, no part of the decision to terminate was based on those discriminatory factors, such as, someone taking a medical leave, someone's pregnant, things like that. So the most common areas we see this come up are with disability issues. So WSIB leaves, sick leaves under short-term or long-term disability, or other requests for disability accommodation, and with pregnancy and parental leaves, whether just before, during, or shortly after leaves. We know, so the first point here, or the second point rather, is that it requires valid business reasons. So we know that some HR folks believe that if someone has taken a sick leave or a parental leave, there's this idea that your hands are completely tied, and even if there are valid business reasons, the employee can't be terminated, but that's not the case. It just makes it a lot trickier. So terminations can be based on valid, non-discriminatory business reasons, such as restructuring, role elimination, etc. That's unrelated to the employee's leave status or their protected ground under human rights legislation. This obviously needs to be handled very carefully, and you will want to ensure discussions are handled with empathy and care, recognizing that the employee may be in a vulnerable position because of if they've taken a leave or things like that. And you also always want to be considering the optics of things, right? You may have valid internal reasons for termination, but you also need to consider how things look or how it will be perceived by the employee or other employees. And that's the sort of the difficult ground you need to navigate when making that decision to terminate. So the upstream tip here is to keep detailed records of the reasons for the termination to show they are non-discriminatory. Important documents may include corporate records indicating the financial need for layoffs, internal communications about the decision, performance appraisals, etc. We always say for any termination, but especially in these trickier instances where they're more likely to become contentious, always write things for the eyes of an adjudicator. So all of your notes, your internal emails, your communications with the employee, think about if they needed to be introduced as evidence or read aloud by a judge in court, and let that guide what you write when you're communicating with an employee on leave or making decisions to terminate. So then next, still on the same topic of protected grounds, leaves of absence, things like that. We're talking about the procedural side of things. So strategic ideas for how to actually conduct the termination itself. First of all, timing. When you terminate an employee on a leave or someone who has raised human rights issues can be just as important as why you're terminating them. Even if you have valid business reasons, you always need to consider, as I said before, the optics. Terminating an employee the day after they tell you they're pregnant is always going to raise alarm bells. So, which leads into the next point, which is, when was the decision made? Document when the decision to terminate was made. It is relevant more times than you think. So in the last example, let's say an employee tells you that they're pregnant and that they will be taking parental leave, and you have internal emails which showed the decision to eliminate their position was made a month ago, and you were just finalizing the termination documents now. While the termination here will still need to be handled sensitively and delicately, that documentation will be key in showing that the employee was not terminated because of a protected human rights ground or because they were taking a job protected leave. So getting in the habit of documenting those key conversations you may be having internally with management or whoever about these decisions, and making sure those documents are dated, making sure you're keeping them in a safe place, that can really make the difference in these types of situations. Another issue with timing is don't mess with EI benefits. So timing of termination and termination payments can ensure that an employee receives their maximum benefit under EI, let's say if they're on a parental leave, and it can generate goodwill and be a sign of good faith from the employer in an otherwise, difficult and potentially contentious situation. So if you need to terminate an employee shortly before or during a parental leave, you can structure the termination so that the employee can still receive their maximum EI benefits, and you can date the termination for a later date and structure those payments or time those payments to maximize that entitlement and to ensure their EI benefits aren't disrupted. This will be different in every case, and this is a situation where collaborating and communicating with the employee may be, a really great thing to do, and working together with them to figure out what's going to work best for them, while still obviously dealing with what the business needs are. But everyone obviously can feel empathy for employees in that situation, and there's ways that any difficulties can be mitigated for them that way. And that will help to resolve things quickly and amicably whenever possible. Fourth point here is to obtain a release. So consider offering the employee in these situations an enhanced severance package in exchange for a release. This provides the employee additional financial security while protecting the employers from future legal actions. We like to suggest always getting a signed release from employees when terminating, no matter what the circumstances, but and that just allows for certainty and closure for the business. But especially in these tricky situations, a more generous severance package and a signed release are going to help ensure that the company is protected. So the upstream tip, which has been a theme throughout this topic, is to take real-time notes of important conversations about employee terminations. As in the pregnancy example, having those conversations documented about when the decision to terminate was made and why can be the difference between a successful and unsuccessful defense to a discrimination claim or a human rights complaint.
Yeah, and I think the key piece here on the exposure, the liability exposure, is that the Human Rights Tribunal and the courts will only need for that termination to be tainted by a human rights claim. It doesn't need to be entirely because of the person telling you that they're pregnant. So that it is, it's not hard to establish that termination is at least in part tainted. So if you have 3 people in a department and you decide that you need to downsize to only 2 people, and you happen to pick the person who just told you they were pregnant, you will have a very steep uphill battle demonstrating why you chose that person. If they're the most recently hired, great. If they've had massive performance issues documented, fine. If there is a meeting minutes where you identify that they're going to be fired, well before anyone knew about the pregnancy and well before they started talking about it in the workplace, or posting things online about their fertility treatments, all of that needs to be completely separated and not tainted. So this one is tricky, and the procedural is really at least half the battle as a substantive liabilities.
Yeah, for sure. That's a really good point, Lisa, that it's not just that there are valid business reasons, but why this employee specifically, right?
Mm-hmm.
If there's 5 people in the accounting department and you say, oh, we need to downsize, but let's pick Sally because she won't be here for the next year.
Yeah.
That's still discriminatory, even if the underlying reason is downsizing. It needs to be completely clean. It needs to be a completely clean decision that has nothing to do. So if Sally has her last 3 performance reviews were, showing that she wasn't completing her deliverables, she wasn't, doing things effectively, that's going to help show why you chose Sally out of the 5 in your accounting department. So you need kind of all of that documentation to be able to show that.
If you're getting rid of a whole department, let's say you're outsourcing it to a vendor or something, then it doesn't matter if there's a couple people in there that are on some sort of protected leave. But it's when we're cherry picking people who maybe just came back from their mat leave last week, or had have openly talked about their mental health issue in the workplace, and you decide to pick them, that all tainted and really difficult.
Yeah, for sure. Okay, so in a similar vein here, we have harassment complaints and terminations. So as I mentioned previously, there are a few key exceptions to the idea that employees can be terminated anytime for any reason without cause. So we've talked about job protected leaves and human rights grounds like gender or disability. The other main category is reprisals under occupational health and safety legislation. So a lot of what we've talked about with leaves and human rights violations will also apply to these reprisal issues. So employers are prohibited from dismissing or disciplining an employee for exercising their rights under occupational health and safety legislation. So this could be refusing unsafe work or making a workplace harassment complaint. So essentially you can't punish someone for asserting their rights. And just like with the other topics, even if you have valid business reasons, you need to be mindful of the optics, and you need to be able to show that it isn't a reprisal if you are planning on terminating an employee after they've made a complaint of some sort under occupational health and safety legislation. So employees in these cases, if they feel they've been reprised against, can bring complaints at the Ministry of Labor, and they can be entitled to reinstatement or to payment of fines and things like that. So you need to be mindful of that retaliation risk and of the optics. Terminating someone the day after they make a harassment complaint is going to be tough to overcome that assumption that it was a retaliation or a reprisal against them. You need to keep thorough documentation of performance issues and non-discriminatory reasons for termination. And this is especially why it's important to think of it as an upstream thing, and to keep good documentation for all of your employees, because you don't know what's going to happen down the line that you may need to be able to show the reasons why you did things. So that doing it throughout, not just for your, difficult employees or problem employees, but for any employee, keeping that documentation is really crucial. And then be mindful of timing. So terminating an employee shortly after they make a complaint can look like retaliation, and it's not difficult to see why an employee would think that, right? So it's best to avoid, if possible, making termination decisions while a complaint, let's say a harassment complaint, is still fresh or unresolved, if at all possible. For any of these situations, right? It's only if it's really business necessary is it going to be advisable to terminate in these situations. So the upstream tip here is to, if at all possible, keep everything separate, maintain separate processes and a clear distinction between, let's say, a harassment complaint investigation and your termination decisions. So if someone makes a harassment complaint and you are in the process of disciplining them about something else, keep those processes completely separate. Don't talk about their discipline in their harassment investigation interview. That's going to really make it seem like those two things are interconnected. So even have different folks in your organization deal with the two issues, deal with harassment complaint, and someone else deal with the discipline or termination. Keep them totally hived off from each other, and that will help keep those optics looking a little bit better for that, for sure.
Yeah, and we see that a lot, right? And these internal investigations where the HR will do a great investigation, and then as they're doing the investigation, it becomes crystal clear to them that of course this person needs to get fired. They know exactly who's guilty and who's not, and so all of the information gets presented at the same time. But what needs to happen is that decision, that fact-finding neutral investigation happens. The facts are arrived at, are the allegations found to be true on a balance of probabilities, and then somebody makes the decision about what to do with those facts. And that is like a separate universe. And so commingling, a termination letter and the results of an investigation, for example, I mean, there is a nuanced way to do that, but ideally you say this is the results of the investigation to satisfy your OSHA obligations, and then here is our action on that neutral finding, and keeping that separate. When we're representing the employee, we go to town on that, right? That is all commingled, it was predetermined, it was unfair, it was biased, and then the whole investigation can get the integrity of that investigation can be questioned, and then you undermine the employer's ability to assert any sort of just cause or a non-biased, non-retaliatory type of termination.
Yeah, exactly.
The other situation we see is when employees start cross-claiming at each other, right? So one person will put in the complaint of harassment against so-and-so, and then so-and-so says, yeah, well, they started it, and then it goes back and forth. And then at some point, often, the employer will say, forget it, everyone's gone. We're getting rid of everyone. They're all bad apples. They just don't like each other. But everyone is entitled to the procedural steps. Even if at the beginning of that investigation you think, oh my goodness, we totally know how this is going to end, just say that to yourself, don't put it in writing, and do the steps.
Yeah, and the people making unsafe work complaints or the people making harassment complaints can sometimes be the people in your workplace that have maybe been difficult in the past. So it's easy to, discount what they've said or their complaints, or just deem them difficult, hard to work with, things like that. That's not good enough. You have to give people their due process. You have to do the harassment complaint. You have to look into the unsafe work conditions, and you can't penalize people for bringing up those issues. And it's hard when someone asserting their rights may be intermingled with their personality or difficulties they're bringing up in the workplace, right? And it's hard to distinguish those things sometimes. But you have to approach each complaint as valid and as good faith unless you have reason to believe otherwise. And that can be tricky when dealing with difficult personalities. So it's definitely something to keep in mind.
It's human nature to find it really hard to be neutral if there's a total jerk in front of you that's treating people badly. But, you know, you got to plug your nose and get through that somehow. Lexa, we have a whole bunch of questions. So why don't our next section is all on executive compensation and terminations involving executives. So before we go to that, why don't we do a few questions here? So let me find the ones that are related to these topics. And thank you everybody for doing all these questions. What if we outline a zero tolerance policy for violence and alcoholism? So presumably if someone then does breach those policies, you know, can we fire them?
Yeah, so that's going to be a really helpful factor in deciding, in justifying a just cause termination, having a policy, and as I said before, applying it consistently, right? Applying it to everyone. So yeah, if someone, and violence in the workplace is one of those situations where just cause is more likely to be met. But having that policy and applying it evenly and consistently throughout the workplace is going to really help bolster any claim of just cause.
Mm-hmm. Mm-hmm. Here's another one then. Yeah, and I think just as a reminder, alcoholism is a disability that's protected. So, you know, there is all the usual issues there of not tainting the termination because someone's has the disability of alcoholism. What if someone has, and this could be a whole webinar, so we'll have to figure out how to answer this one in a short way. What if someone has been on LTD for more than 2 years and likely never coming back? Is there a frustration of contract? That could have been like that, and then terminating older workers. Those two are hot bananas right now that we don't have a lot of content on for today because they're too huge.
Yeah. So frustration of contract, for those who don't know, is essentially when through the fault of neither party, the contract has become impossible to perform. So if someone is on a medical leave and it looks like they will never recover, there is a possibility that a frustration of contract argument could be made. It's going to depend on the medical evidence that's available. So you'll need to ask the employee to speak with their medical provider and get pretty detailed medical documentation. And again, as Lisa said, this could be a whole webinar in and of itself. So it is something you may want to get legal advice on. But yes, there's a possibility that a frustration of contract argument could be made. And then in that case, the person is only entitled to their Employment Standards Act notice of termination, not that larger common law piece.
Yeah, keep in mind that in Ontario, there's a regulation that specifies that even if it's frustration, like valid frustration, they're still entitled to ESA.
Yeah, but that's different in every province. So if you're in a province other than Ontario, you'll want to take a look at your own legislation for that.
Here's an easy one. Will the recording of this webinar be available to participants after? Yes, it will. And we have a YouTube channel, so just in a couple of days, we'll get it posted on that. Can you terminate an employee who has been off work for years and has not been approved for STD or LTD benefits, but continues to bring medical notes indicating they are unable to work?
So that's going to be similar to the last one. That would be a frustration of contract piece. And I should say, you know, if the contract hasn't been frustrated, you still have an obligation to accommodate the employee, which may look like continuing to have them on an unpaid leave or an STD or LTD. It's one of those annoying lawyer topics where so much of it is, it depends on the exact situation, but yes, if the frustration of contract test is met, then that could be a case of frustration, but it's going to depend on the facts.
Yeah, and you know, in this one, the fact that the worker doesn't is not approved for LTD. I find that an interesting factor to explore because, you know, the case law talks about when there is an LTD program in place, the parties have clearly contemplated that there would be that the employer would take care of the employee. That's why that program's in place. If the person doesn't qualify, why? And so that's, you know, you know, typically the employer is not obligated to do more than help facilitate a person to the existing benefits. So again, that is a whole separate topic, but approval of LTD is something to explore there.
Yeah.
Here's one that we run across, I feel like every day. How long does someone need to be back from an unpaid stress leave before you can terminate them? And if that employee already has performance issues and since the termination was coming and went on leave before the termination could happen, we can write the playbook on that one because that is a very common scenario for sure.
Yeah, absolutely. It's going to have, you know, you're going to want to think about the same principles we were just talking about. Do you have documentation to show valid business reasons? You know, in terms of timing, obviously the longer time has elapsed between their leave and the termination, it's going to help it seem less discriminatory. But there's no magic number, and you have to weigh the risks of a discrimination claim with the risks of, you know, having this person in your workplace and the cost of having them in your workplace if they're not being effective or if they're being disruptive, things like that. You know, and you do also, again, if they've been on a leave for medical reasons or mental health reasons, you want to make sure you're still abiding by your duties to accommodate. But if there's separate from any health issues, if there are performance issues, you know, you can terminate, and there's unfortunately no magic number. The longer you wait, the less connected the two events will seem, but there's no perfect time, and it could be a year later and the person could still assert it was related. So, you know, you have to sometimes weigh those risks and just hope you have the, you know, try to gather the appropriate documentation and things like that to build your case that it's not discriminatory.
Mm-hmm. We do get a lot of employers with this issue, a lot, and I think one of the most difficult pieces of this is how do you separate out what was a legit performance issue, they just weren't that competent, you know, or you know, they weren't trying, like whatever, a legit performance issue versus a mental health issue or physical health issue, you know, a medical issue that is somehow driving the performance. And unpacking that is impossible. None of us are doctors, but I post-COVID, this I have to say is probably one of the most common issues that we're dealing with all the time, and it's difficult. But having that time, that separation is key. Lots of documentations, etc. But at some point, the business has to just make a decision that there is in fact no risk-free way to do this. And so, you know, we're not the type of law firm that will say, okay, there's a 1% risk, so never do it. Don't break the law. But if there's legit performance issues and you know that this is not related, then sometimes you got to pull the plug and just get ready for the claim and get ready to put a lot of money on the table, which, as you said, may ultimately still be less than the cost of all the resources. If you're, you know, consulting with external counsel, if you're, you know, losing clients or customers, you know, that's math to incorporate in this as well. Okay, the questions are coming in. Let me try and find one. A contract employee might not complain, fearing retaliation and team isolation and career impact. What are their options in terms of timing and registering complaints after termination? So I don't, I'm trying to think of, so if you are, this is probably more for the employee side here, when is a time to file a complaint? But for, you know, our audience is employers. So for employers, you know, there's limitation periods. People can file complaints well after a termination. They can bake it into their statement of claim or their applications to the Human Rights Tribunal for sure. You know, real-time complaining is really the best approach. filing a real-time complaint. Doing it well after is difficult, and then if the company is not aware of the complaint, then they are off the hook for having to fix it or address it. So I think an employee shoots themselves in the foot if they don't raise the issue, even though it's very difficult to do. I fully appreciate that. It's scary, it feels risky, I get all that, but it needs to be done in the moment-ish or slightly after. Let me do one more and then let's switch over to exec comp. I know there's a whole bunch here. If someone has been on a medical leave for over a month and the manager or HR person can't contact them after multiple attempts, at what point can we end their benefits and or proceed with a job abandonment termination?
Job abandonment is tricky and it will depend on the circumstances. I think a month is not going to be quite long enough to assert job abandonment, but it's also always contextual. How long has the employee been employed before that? You're not going to be able to successfully assert job abandonment for a 20-year employee after a month. The threshold is going to be higher than that. And you'll want to do things like registered mail being delivered to them and trying multiple phone numbers, multiple email, and giving a fair bit of time. If someone's on sick leave, you know, they do need to be given some time and space to recover, and they're obligated to be in communication with you, but the timelines are fluid. There isn't any strict timelines. So I would say generally a month is likely not long enough. And I would continue trying different avenues and making sure that, you know, in your communications, you're saying, if we don't hear from you by X date, you know, and what actions you'll be taking. So putting them on notice that you're really expecting them to reply while still being empathetic and kind and understanding that they are on a medical leave, and writing those things for the eyes of an adjudicator. That's a really key one in this type of situation. But yeah, just keeping those lines of communication open, and there isn't, again, any magic number of time for a job abandonment.
Exactly, but I love your answer about try different ways to contact them. The big question I often have with clients who want to do this is, what's the hurry? You know, what is it costing you? These are usually unpaid leaves. They're so yeah, maybe some benefits, less $500 a month, maybe, you know, like I know there's user fees and you know, seat costs and all of that, but in the big picture, waiting another month is going to be way more cost effective than triggering something too early. I would say you want to be reaching out to them at least half a dozen times in all different ways before you even begin to think about job abandonment. And I don't understand why clients are in a hurry on this one, other than people are annoyed and they want closure. But just, yeah, cool your jets. It's usually what I want to nicely say to clients on this one. Okay, thank you everybody for so many questions. I see so many of them. Clearly we need to get some blog posts going on this topic, because there's a lot of, so we'll capture the questions and try and get back to people. Absolutely contact us if you've got some specific ones. But let's shift gears to senior execs. I want to make sure that we end on time so that people can move on to their busy day. So why are, and I get to talk now because this is my favorite topic. So why are senior executives, why are their terminations complex? They're tricky because they have awareness / ego maybe around their entitlements. They can afford to fight usually, and there's just way more dollars at stake and equity issues at stake. So there's just more motivation to fight. There's usually, and they are bosses themselves often, so they understand what they're entitled to and what all the comp issues look like. So, and they often help negotiate their own contract up front. So, you know, there's lots of, it's a different person at the table that you're negotiating with. They are usually entitled to a longer notice, in part because they are, the common law rationale is that they, when you get into these very specialized senior exec roles, there are few of them available, so they just need that longer cushion to find another job. It used to be more of a classist, they're special, but that's not the case. Now they need that longer cushion. And the other big reason why they're tricky is there is this nexus with corporate law for senior execs, with equity, with director and officer roles, with board positions, and this intersection with corporate law makes it more complex than a basic termination package that many frontline HR might be handling. So, for example, if the exec is a director and you're terminating their employment, there's extra steps around removing them as a director, which may require director resolutions at the board level under the corporate bylaws, doing a corporate filing, getting resolutions if they're an officer. Take a look at their director and officer insurance, but don't be hasty to cut it off. Wait for any potential claims to get resolved. And then there might be public disclosure with your securities regulator if you're a public company. So, if they're a director with a company, there's all these extra layers to think about. For secret sauces, IP, non-competes, non-solicits, and equity, I'll be talking about them on the next slides, but they are why these terminations are tricky. But let me talk about how to terminate an executive. And I would say there's 5 main steps: scope, gathering, timing, context, and math. So the first step is consider the scope of their compensation. Understand all the components. It may look like they have a super high salary that's, a billion times more than many of your employees, but that still might only be 50% of what they're taking home when you look at their bonuses, their equity, their health savings account, their car allowance, their professional dues, their gym membership, their pension, all their pension plans, their deferred comp plans. So understand the scope of what their compensation is. And then number 2, gather all the governing documents around this, get a folder going and start putting it in so that we understand here's the base salary, but then here's all the other things that they may be entitled to on termination. The third step is to consider timing. So unlike what Lexa was talking about with harassment and leaves, the timing here is more around their compensation. So is there a big bonus payout coming up? Are you at the, is the quarter of a fiscal where that's normally paid out coming up? Is there a vesting cliff for any equity? Is there some big corporate event coming up, like a merger or some sort of change in control provision, an IPO that might trigger some of this? And if firing someone right now disentitles them to hundreds of thousands of dollars, there will be a fight. So consider the timing of when the termination happens. Context is important for the termination. Are they a good leaver or a bad leaver? L-E-A-V-E-R. Are they leaving badly? Are they? And these are defined terms in the executive contracts. So good leaver examples are death, disability, without cause, change of control. Bad leavers are just cause, certain types of resignations, and that will trigger different paths of entitlement. So usually they're a good leaver, right? And if it's a good leaver, the context of that termination could impact the size of their termination package and sometimes double or triple what they would normally get through contractual indemnity provisions. And this is a different bucket on top of the regular common law termination payments. So understanding the context of their termination and what provisions are being triggered will be important. Often executive contracts will also cover off constructive dismissal issues, like if there's a merger and you're significantly reducing the CEO's role, who's now only VP of a department. Those are often considered change in control or good leaver reasons that might also trigger this, double, triple their package. So keep an eye on that context. And then finally, for just cause, sometimes you'll see an executive, you'll see in executive contracts, a laundry list of the things that amount to just cause. Because they're an executive, because they're in the C-suite, they'll have, additional fiduciary duties, for example. But ensure that in the context of all that, if you are looking at firing someone for just cause and triggering the bad leaver provisions, that you are aware that whether or not minimum standards are still going to be required, because that all these other executive just cause reasons may not rise to these basic levels of the minimum standards. So, you know, they're not exempt from the usual provisions around all this. And then finally, the last step is math. Get your spreadsheet going, do the math up front before you announce the termination. Understand all of the likelihood of being able to enforce any of these documents. What do the numbers mean? And that will always require a spreadsheet because there's all the different components of the compensation. And just to know that the employee shall fight back. They just always do when there's a lot of variable comp on the table. So for the upstream tip, really focus on the non-base salary comp issues in exec contracts, and then make sure you're syncing that up with the employment agreement, with any policies and plans around bonuses, commissions, equity, and other perks. So syncing that all up. Let me talk a little bit about equity. The starting point for all equity is that equity rights do continue during the notice period unless there's some sort of contract language to restrict those rights. So you really need to figure out which documents are going to govern all of this. Note that if you are terminating someone and the settlement negotiations go a little bit south, and timing around the vesting equity, if there's any cliffs, if there's any equity that ought to have been on the table, if there's a corporate reason why that timeline, you know, the ship sails on that, courts will still just assess the damages of what the person lost. So, you know, it's not some sort of fun loophole. They will just, rather than granting the actual share ownership, they will assess the damages and award loss of damages on that front. So, you know, the equity is always a really big part of the litigation. So your big picture steps for analysis are, first identify, is this even equity? You know, or is it just a really fancy bonus plan? But is it equity, and what are the terms that govern it? Number two, would the executive have earned this equity during the notice period? And then we go into the battle. So are there any terms or events that might trigger or end the entitlements? Is there a change in control position provision? Are there accelerated vesting provisions if if there is a termination? What happens to unvested options? Are they forfeited on termination? And then the fourth step is when. When do these equity rights end as per the contract docs? And this is where all the battle is, because the end of the end of employment can be a whole bunch of things. So the case law is doing all this interpretation on things like upon termination of employment, when employee ceases to be employed, are they actively employed, continuous employment. There's just all these phrases that have been peppered through employment contracts over the years that the courts are really interpreting right now to decide, when is this notice period ending, and when do the equity rights end? So it is that issue is a very big chunk of the case law on this right now. So I think it is important to really get granular with this, what rights end as per the contract. So upstream tip, tighten up your equity share docs, of course, but then, or your equity docs, but more importantly, share them with your employees, with your execs early on, because if you fail to share any restrictions that exist in some of the governing documents, the employer can't rely on them in the future if the employee just wasn't aware of it. So just it could be all this hard work that is undermined by not sharing. Okay, let's talk about secret sauce. The best way to protect your employee, or the best way to protect the company against IP, client relationships, all of that is contracts. This is all a contractually governed thing. Now, what happens if that ship has sailed? You've got to terminate someone right now, and you take a look and there's, a totally unenforceable non-compete, and they didn't sign anything, and it's all a big mess. Here are some practical tips. that you could consider doing to help protect the company if they have, key client relationships that you're worried about, or intellectual property. So number one is money. You can increase the termination package to add on a more robust non-solicit and confidentiality term in the release. That will cost you money, right? If you're asking people to sit on the bench or not be able to use their skills, it's possible, but it's costly to an employer. It is important during termination meetings to really remind employees about their post-employment common law duties, and work at retrieving the data there as much as you can, obtaining computers and all that kind of stuff. Do it in the moment to try and mitigate the loss as much as possible. In some circumstances where you're really dealing with a very senior person with a ton of critical secret sauce, you could also consider engaging in a post-termination agreement. Again, will be costly, but it is an option. You can bring injunctions to enforce your common law rights that an employer does have around confidentiality. And then really go hug your clients and really monitor any employees that might be allied to this executive that you're needing to get rid of, and do what you can, divide and conquer, and really solidify relationships with customers, because this really is a tough moment in the relationship. The upstream tip is, is contracts for sure. Okay, one last quick topic. I know I hammered through that fast, but realistically, it's a very expensive type of termination, but it's not as common as all the situations that Lexa is covering. So we knew we would zip through this part fast. For mass layoffs, this is a nice quick slide. Basically, they're tricky because they trigger large statutorily mandatory notice periods and reporting obligations to the government. So watch out for what number of employees will trigger the mass termination or group termination layoffs in your local province or territory. So 50 plus in a bunch of them, 25 in some, and then 10 in others. And then the other piece to keep an eye on is all of them have some sort of rolling window. So you can't just do 50 today, 50 tomorrow, and 50 employees the next day. It's in Ontario, at least, it's 50 or more within a single establishment within a 4-week period. So you need to keep an eye on if you're doing some restructuring. Did you do something 3 weeks ago? Because that's all going to be added together. Remote employees are now part of the mix, and if you've got more than one location, especially if they're nearby, they will likely be considered a common establishment. So the government keeps closing the loopholes on this. So they're tricky. And then the other two pieces to really think about, you want to budget for this, because these are mandatory payments. These are Employment Standards Act payments. So if you have a particular termination, it could be up to 16 weeks of mandatory amounts that you have to pay employees. So it really can add up. And then communications, a really important step to balance the employee morale. You're looking at longer periods, big groups that are all going to talk to each other. So I know you always need to balance all of that, but in many situations, a mass layoff is part of some sort of business restructuring, maybe a merger, and so there's business and trade secrets going on there. So it's always that balance to communicate as much as you can without breaching the terms of some business arrangement that's in the works. So it's tricky. If you're unionized, talk to your union and make sure they're part of the loop. That's mass terminations in 3 seconds. So that was fast, but basically you just got to do what you have to do on those because the legislation is pretty clear. Okay, wrapping up. For tricky terminations, plan, and then budget, because these will always cost more. Hopefully they're one-offs in your organization, but they just always cost more. It's hard to get around that. Know your overall contractual and legal entitlements to inform business decisions, and not the other way around. Don't let your business decisions always inform the contractual entitlements, because those might bump up against each other and get you into very expensive hot water afterwards. So they do need to sync up in a logical way. And again, budget for these higher costs of settlements. Lexa, do you have anything to add on the wrap-up slide here?
No, I think you've got it.
So
That's
we
great.
did have time for questions, we don't have time. We did include a question slide, but unfortunately, there's a ton of questions that we didn't get to. So we will review them after and try and get some communications out in, upcoming blogs. But I want to make sure people can head out as we promised 1 hour later. So thanks for joining our webinar today. Our next session will be on October 16 at 10:30 a.m. We do the third Wednesday of the month, and that will be on workplace investigations. Please feel free to follow up with any other questions. Come visit us at springlaw.ca, follow us on social media, sign up for our newsletter to stay updated, and we will see you next month.
Thank you.